Hey, I've been around digital marketing for a long time, but before that, I was in offline marketing where I was familiar with people who needed patents for products that they were doing. But it occurred to me that a lot of digital marketers today don't have a clue about the kinds of protections that they need for their assets for their business. So I've asked Marc Hankin, and a patent attorney, to join me today to kind of answer some of those questions that I had. And I think they'll help a lot of other people in the industry too. So first of all, welcome, Marc.
Thank you. Good to be here,
What
Jan.
I'm going to read a little bit of the bio that you have. It's extensive, so I'm going to post a whole link that you offer for that. But Marc is the founder of Hankin Patent Law, and you'll get some enlightenment from this today. He's a registered patent attorney with an extensive background in intellectual property rights. While he got his degrees on the East Coast, I noticed, Boston University and University of Pennsylvania, he's now on the West Coast with offices in LA and the Bay Area. Marc has advised owners and managers of all sizes of companies on how to best protect their intellectual property and their creative works through patent prosecution, trademark and copyright registration, licensing agreements, and trade secret protection. So I'm thrilled. I'll post a link to the extensive background that he has, including service on committees that went to The Hague. Thank you again for joining me.
My pleasure, Jan. It's great to be here. Thank you.
So, thinking about these digital marketers and their problems, it seems like it is the scope of intellectual property. And to be able to help these people, I want to give them an understanding. We're talking about course creators, podcasters, authors. I mean, it's just anybody can create anything digitally anymore. And so
Right.
knowing what to protect, when to protect it, I think is something. So maybe you can give me an overview of some of the protections that these people need to think about and why that's important. Some of them, I know authors sometimes today aren't copywriting their material because there is some kind of protection, but I'll let you talk about but thinking about some of these, even solopreneurs or people who have a business that want to sell the business later, they're creating a value.
It's true. So, Jan, part of the problem is that some folks misunderstand intellectual property law. Some folks are actually just morally opposed to it, and others just are willfully ignorant. It's a complicated area, and as a lawyer, I've been doing this. Well, I graduated law school more than 30 years ago, and I know a lot of lawyers who don't understand the differences between patents, trademarks, and copyrights.
Whoa.
It's always a little shocking to me. In fact, I have a new lawyer client who has been getting it wrong from the beginning, and I keep trying to educate him. Hey, dude, let's get this right because you're a lawyer. You should know better.
Right.
But they don't. So the layperson can't be, they can be forgiven for not understanding the distinctions. But let's break it down a little bit. Just because you can find something on the internet and make a copy of it does not mean you're entitled to do so. In fact, there are companies out there, I like to call them copyright trolls, but there's companies out there that sort of make their living, their business model is putting things out on the internet that are very attractive, waiting for someone to copy it, and then pouncing and charging them just enough money that is more than they want to pay or ever would have paid, but less than you can afford to pay a lawyer to fight you. In other words, to hire me and fight will cost more than just paying the blood money. And there's a number of law firms that do that. There's a number of companies that do that. Some of them have very highly respected names associated with them, but they're just trolls.
Wow, that's scary. This is the first time I'd heard of that, but I'm not surprised. I mean, there's
Yeah.
just a lot of crazy stuff going on right now.
Well, for example, one of my clients had something that included a finish line. And so they showed a checkered flag. You and I have seen checkered flags our whole lives. And I Googled checkered flag image, and there's thousands of them. They could have picked any one of those. But the one they picked, somebody came after them for quote unquote copyright infringement and shook them down for $1,000. It's a shakedown. It's no different than going out in the back alley and threatening to break someone's kneecaps if they don't cough up their lunch money.
Wow.
But this is what they do.
All these digital content creators out there that are picking up images to put in their blog posts and in their courses and everything. And I do know of one instance where an ad agency was told that a client had rights to some creative and they didn't. And both the ad agency and the client got sued.
Jan, I once had a client say to me, I have a license. It said I could use it for commercial purposes. It's okay. I don't know why they're coming after me. Well, I may or may not be smarter than some other people, but I certainly am more educated in the law. I said, let me see the link of where you got this from. And I went, and sure enough, it says in big bold letters, you may use this for any purpose, including commercial asterisk. Well, I'm a lawyer and a New Yorker, so I'm a little questionable. Or I should say questioning. I'm also questionable, but I'm questioning, a little cynical. I said, let me see what this asterisk means. And you click on the asterisk, and then it says, to use this, you must put this statement everywhere you use it.
Attribution.
Now, a normal person would never look at the asterisk.
That's right.
Nor would they see it. And it's big bold letters, you may use it. But then little asterisk and little link, it says, but you have to do this. That is, I'm sorry, Jan, that is intentionally misleading the public.
Right.
And my client fell for it, like so many other innocent, honest people who would never violate the law if given a chance, but they're not given a chance because it's a trick. This is entrapment, and it's terrible. It's a terrible thing. So I tell my clients, don't put anything on your website. Don't use anything in your materials. Don't put anything in your PowerPoint unless you took the picture yourself.
Right.
I had one
Good
client,
advice.
Dan, I had one client who was a car enthusiast. This is not his business. He had a bit, I don't remember what his business was, but he made money. He was a car enthusiast on some weekends. Had a really cool car, went to a really cool car show in Northern California. Whole bunch of people sitting around with their cars. And you know what people do? I don't know how often you go to car shows. I don't go very often, but I've been to one or two. People walk around and look at the cars and say, that's a pretty cool car. So some guy came over and took a picture of my client in front of his own car. Took a couple pictures, posted them on the internet. My client never signed a document saying you have the right to use my picture, never said you have the right to use me, but he was out in public at a car show.
Right.
So one of my client's friends sent him a link and said, hey, I just saw some great pictures of you on the internet. Look at this. My client posted those pictures on his hobby website, not his business, not making a penny. He literally didn't make any money from this, nor did he try to make any money from it. And he just simply said, hey, here's some pictures of me, and he put them up. The guy sued him for $5,000.
Whoa.
It's himself and his car.
In public,
but somebody took a picture, and then my client, for putting it on his website, not offering to sell it, not trying to take away any sales with this guy, not doing anything commercial, was shaken down for shaken down an attempt to make $5,000.
Everything's up for grabs.
It sure is.
So my friends who are authors who choose not to do a copyright,
right?
What do you think about that?
So in the world, the largest international treaty I'm aware of anywhere is the Berne Convention, which basically is a copyright treaty from country to country to country. I forget how many. It's about 200 countries or signatories to the Berne Convention. So you do not need to do anything. The minute you fix in a medium some content, take a picture, write it down, you're recording this conversation,
right.
You're fixing in a medium. Anything that is fixed in a medium, you immediately have a copyright in. However, do you know the largest library in the world?
Library of Congress?
You know it, Jan. And you know why and how? Because they require you to submit a deposit of your material if you want to get a copyright registration.
Right.
And
send us 2 copies.
Exactly. The federal courts say you may not sue on your copyright unless and until you have filed a copyright application, i.e. send your deposit to the Library of Congress.
Oh, okay.
So in the United States, you must, if you want to enforce your copyright, you must file a copyright application. Now, a publisher, a big book publisher or magazine publisher, newspaper publisher, they're in the habit of regularly submitting their works for copyright infringement, for copyright registration. And so they would do that for you if you're a published author. If you're self-publishing, you need to do it. You can hire a lawyer like me or some other copyright lawyer to do it, but you can do it yourself. It's one of the last bargains the government gives. It's still only $65. And you can file it electronically and you can upload the image. It's not that hard. And then you submit it to the government. They then will give you a registration certificate that literally they take your application, they photocopy it onto cardstock, colored cardstock. And these days, it's not even really cardstock. It's just a little
just
less
paper.
Yeah, exactly.
Yeah, I got one.
Right. And then you have a copyright. Now you can sue on it. What's interesting is if you don't file within the first 3 months, then you're not going to be eligible for statutory damages or attorney's fees. And if someone does infringe. If you do file, and then there's some nuance to this, but the bottom line is you want to file immediately or within 3 months. So as soon as it's published, and I tell my clients, if you're generating a lot of content, just file everything every 2 months. That way you'll never miss the 3-month window.
Oh, okay.
But basically, if you generate something, file it for copyright protection, you then could sue somebody. And if they knew about your copyright or if they willfully copied it, they took it off your website, you can get up to $150,000 in statutory damages, which means you don't have to prove you would have made $150,000 worth of sales. And if you have to hire a lawyer like me to enforce it, you could get your attorney's fees back from the defendant.
So does that hold true for a course creator? If
they create a course and they copyright it and someone copies it, then yes, it holds true.
Okay.
There's websites out there. I don't know if you're familiar with the lawsuit I had this past year, but
I did see the link to that.
Yeah. I represented a professor at Chapman University in Orange, California. His students cheated on an exam. They posted the materials on Course Hero. That's the website that owns the Cliff Notes, or the company that owns the Cliff Notes. And the website is designed to help students cheat. Its entire purpose is to facilitate buying term papers, buying answers to essays. They're people that are supporting students for cheating. All of my kids, two of them are out of college, but one's in law school, but one's a junior. They all know about this website. Some of their friends use it. There's other websites out there as well. Clegg, I think, is one of them. Anyway, these websites exist for people to post professors' materials on and to try to buy answers to it. It's a institutional cheating, corporate supporting of cheating.
Right.
And they basically violate the copyright. And then they hide behind what's called the DMCA, the Digital Millennium Copyright Act, but that actually doesn't apply to them, and they don't realize it, and they are hiding behind something that they're not eligible to hide behind. It's really quite shocking, actually.
Yeah, I wrote you the story. I heard the horror story about somebody who said their entire course was copied, and they were like, what do I do about it? They needed you.
Well, I teach a lot. I'm a certified science teacher in New York State, K-12, but in teaching business school, law school, colleges, high school. Anybody who wants to learn about intellectual property. I love guest lecturing, and I've done that all over the country. In fact, I'll be teaching in DC in October. In any event, the professors or the teachers who spend a lot of time and effort putting together a course should put a copyright notice. Put a running footer on everything you do. Just put a running footer copyright notice. You put the C inside a circle, not parentheses. That doesn't count. It has to be inside a circle. C in a circle or the word copyright.
Control-Alt-C on your computer.
There you go. Exactly. The year of creation, or sometimes if it spans several years, you've revised it. The range of years of creation. The name of the copyright claimant, and then for some of the countries that are not in the Berne Convention, add the terminology "all rights reserved" with a period, all additional caps, and add that on there, and you're good to go.
That explains it. Yeah. So, and then each year you need to look at your website and your materials and update them, because I've seen things that say, a previous year.
Right. It's one of the first things I look at when I see a prospective new client or opposing counsel or somebody I want to know, are they savvy about intellectual property? I'll look and see if their copyright notice is updated, because that's just a simple way to see if they're actually paying attention to things that matter.
Right. Oh, very good.
Yeah.
So to talk about trademarks a little bit, when should a digital content creator think about a trademark? And
so remember that a domain name is not trademark. A domain name could be an address. My office is on Wilshire Boulevard, one of the longest streets in Los Angeles. And there's a lot of firms, a lot of law firms in my building, plus every other building or many other buildings on Wilshire Boulevard. A web address, a URL, is just an address. It's a place where you can find somebody. What goes on there might be trademark use, but merely having the domain name is not trademark use by itself. You have to use it as a trademark. So if you're creating digital content, what you want to do is, and I like to use the example of Nike because everyone understands it. I actually don't work for Nike, but everyone understands it. Nike is the house mark. That's the brand name. Swoosh, that's their logo. And Just Do It, that's a tagline. So any of those three, the brand name, the logo, the tagline, could serve the function of a trademark. And any of them could be for balls, for clothing, for exercise equipment. So they all could be in different classes. So when you're creating content, you might have a really nice thing that you say. Maybe you'll copyright that, maybe you won't. But if you have a tagline, you could trademark that. And again, you could just put a notice on there. If you're selling goods, the world of trademarks is divided into 45 classes. The first 34 are goods, the last 11 are services. So if you're selling goods, balls, electronics, clothing, games, toys, nutraceuticals, lotions and potions, those get a TM. And if you're like you and me, we're doing digital content, we're doing legal services, we're writing for people, we're blogging, we're advertising. Those are all services that gets an SM. You can only use R inside a circle after you have a registered trademark. So unlike with copyright, where you can use C in a circle just without ever filing the application, with a trademark, you can only use R in a circle if you file the application and your application is granted and the trademark is registered.
And is the register mark more defensible than the trademark?
So if you get it registered, it's got certain legal presumptions that come along, which means you don't have to prove them in court. It'll prove that it's a valid trademark. It's to prove you're the owner. It's to prove that you have use for these goods and services that are listed in the description. It's really powerful to get a registered trademark. However, you do have common law rights if you don't register. So even before you register, and unlike with a copyright, remember I told you there's that 3-month window, and with patents there's a 1-year window. With trademarks, the longer you use it, the stronger the trademark becomes. But it's better to have the registration because that will keep others from getting a registration. You don't want to be somebody who's used it for 20 years fighting some guy who used it for 1 year but got the registration ahead of you.
Can you imagine?
I do it all the time. I guess you can.
You've seen the cases.
Exactly.
So in the world of patents, I'm pretty familiar with it from either the SaaS platform software usage or for physical products, because I worked in the infomercial industry for a long time. But when it comes to digital marketing, they're creating these entire processes for people, and they're basically software as a service, but I don't think the digital marketers think of it that way. So they're putting these templates to be sold or leased or whatever in Trello, for instance, or on other platforms, and I don't think they realize what they've got here.
So Jan, part of the problem is that patents were originally not covering software.
Right.
And it was in 1980 that a lawsuit went up to the Supreme Court and that granted protection. It was Diamond v. Deere is the case, and it granted protection for software. Then in 1996, a case called State Street Bank allowed business methods to be protected. Well, business methods like DoubleClick, okay, this is an example.
Sure.
So there's many apps, all the .coms that, some survived the 2000 bust and some didn't, but all those .coms, they all had business methods. Well, through a series of cases, started out Bilski and Festo, and eventually the Supreme Court case of Alice against CLS, or CLS against Alice. The Alice case, Alice case, basically said you can no longer protect business methods. So State Street Bank was eventually overruled. And what that means is that just because you do something with a computer that you used to do with paper and pen does not allow you to protect it with a patent. So a lot of the digital work that you and I see on a regular basis are very cool things, but they can't be patented because there are digital methods, they're business methods. Now, software still can be patented. And I listened to the Supreme Court hearing of the Alice case. And it's quite interesting because the Supreme Court wanted to outlaw software, but it wasn't a software case. It was a business method case. And for these many years, for the last 8 years, I've been telling clients, one day you may not be eligible for a patent on software, but I would much rather have you have an application pending in case it still is eligible rather than don't file. And yet many software writers don't like the patent system. They don't want to have patents. So some of the best prior art is not findable on the internet. It's not findable in the patent office because it's being hidden or it's just not being filed on.
Well,
nonetheless,
but these are business processes. So if they file as a business process,
you cannot protect it with a patent anymore. However, if there's a methodology, the Supreme Court said the test you've been using isn't the only test, but we're not going to tell you what test it is. Still, the what they call the machine or transformation test is very helpful. If you use a machine other than a computer just to crunch numbers and process data, then it could be patentable. And if you transform data other than just data processing, then it could be patentable. I think that helps people understand that if you have a system, a methodology that's more than just using a computer to make your life faster and easier, then it may be able to be protected. Software can be protected. And what I love to do, what I tell clients, let's take your GUI, your graphical user interface, print the screenshots. Tell me what a user would go through. So the user goes here, we print it. User goes here, we print it. User goes here. And then we print those screenshots, and then we explain to the patent office how the methodology works and what you're able to protect and why it's different from everything that's come before and why it's not simply a business method, but it's actually a patented method. It's a system. And then we're able to protect it. But many methods are just business methods. It can't be protected. So it only works if it actually is a more robust system.
Right. So a lot of these companies, they're small business, they're solopreneurs.
Sure.
These are people who are starting to think about, at some point, this is a legacy they want to pass on to their kids, or they want to sell it. They want to put a valuation on it. And I know you've written a little bit about that, but maybe you can kind of give them a heads up about, you need to think about what you've got here.
Absolutely. So sometimes people have value in their intellectual property, and it may be more than their house or more than their bank accounts, but the intellectual property is what they have left. And that's going to be for their children and their grandchildren. I represent some famous authors who have some books that we've all heard of and maybe we all read to our kids or our nieces and nephews. And some of those are famous. And when the author dies, you have to assign the copyright. Sometimes there's a trust in place. Sometimes it's just directly left to the children. It's good if you talk to a trust lawyer. I don't do that work, but it's good to talk to trust lawyers and get somebody to put that in a trust for you. And then the money can be split up later. The ownership, however, can be maintained by an entity that follows the author even after the author's death.
Like the trust, right?
The trust.
Right. And then the kids can still make money from the book. I mean, I know some authors that are just putting their books in the latest version of a printing. Right. So it's been out there for years, but there's a new one, and
and sometimes movies get made, derivative works, movies get made, and TV shows get made. Sometimes somebody picks up an old story and says, this would make a great TV show, and let's make it. And it's years later, but now all of a sudden it's current again.
And some of these people are vocal coaches who have blogs and courses and materials that they want to pass on to the next generations. Yeah. Absolutely.
And a little bit of ounce of prevention is worth really a pound of infringement.
They need to think about this as part of whatever their estate planning is. You're right.
Right. And the government's been helping. The government actually has allowed people, widows and orphans, to come back and reclaim copyright after a certain number of years and to try to help right some wrongs, because sometimes authors are desperate and they sell for too little, and then later the family hasn't benefited, but the government's trying to help the family benefit a little bit from something.
Well, and better to do it before so they don't have to deal with it, right? So reduce what your kids have to deal with. So one of the things I just noticed this morning was one of your pieces about the California work from home. There's a lot of people who they're just very busy with their businesses, and they're starting to outsource some of the writing that goes on. And so I noticed you had a comment there about the work made for hire that
right?
should go into agreements.
So it's very interesting. This is probably beyond the scope of our recording today, but very quickly, the Supreme Court, in a case called CCNV v. Reed, explained what a work made for hire is. So if you have an employee, everything they do while on the job belongs to you. The employer owns their creativity on the job. If you have an independent contractor, you're contracting with them to do something, but it may not be create content that the employer will own because it's not an employee relationship. It's an independent contractor. They're not dependent. They're independent.
It's a freelancer, right?
A freelancer. So we've been telling clients for decades, since CCNV and V Read in the early 80s, we've been telling clients for decades to make sure to put this special work made for hire language in the employment agreement and in all of your agreements with independent contractors to make sure that you, the employer, own the rights. Because often the employer's our client. We do represent employees, but often the employer's. Well, California changed the rules on independent contractors. There was a case called Dynamics, and the Dynamics case led to the AB5 rule. AB5 is the Assembly Bill 5, California law, which codified, it took the 11 categories that you used to look at to see if somebody's an independent contractor and shrunk it down to 3, A, B, C. And B is really the most important, which is, are you doing the same job that we're doing? So, for example, if I have a law firm, I hire a lawyer, they're practicing law like we are, that's doing the same thing. Now, there's some exceptions, including lawyers and CPAs, of course. But in general, if you have a company and you've hired someone, for example, if you're a digital marketing person and you hire somebody to do digital marketing for you, all of a sudden that person is actually doing what you're doing. They're probably an employee and not an independent contractor. Now, I'm not an employment lawyer, and this is not legal advice. However, in a situation where somebody might properly be an independent contractor, under California law, the insurance code has been changed to conform to AB5, and it says that if you use the work made for hire language, that person becomes a statutory employee under California law. Wow. So you have to give them rest time, meal breaks, pay them overtime, all the employee, but maybe give them a health insurance plan, give them vacation time, everything that you tried to avoid by having an independent contractor. You have to collect payroll taxes and pay the employer's part of payroll. All of those things that you tried to avoid with an independent contractor, now they become a statutory employee. So in the state of California and any other state that has a similar rule, you better make sure to review your agreements and not inadvertently convert an independent contractor to a statutory employee by leaving in the Supreme Court mandated work made for hire language that's good for copyright, but not good for employees.
Oh my gosh.
Yeah.
Times are not easy. Well, I want to make sure that people know about you and know they can rely on you. I recommend that people look at your website, hankinpatentlaw.com, to get more information. And thank you. I noticed that you've got an audit that you can offer. So maybe you can say a little bit about that, and we'll tell people to go find that.
Absolutely, Jen. So a lot of times people don't know what they own. I get involved sometimes in M&A deals where one company is buying another company. And if I come in on behalf of the buyer, I often look at the list, the schedule of intellectual property. I'm amazed at how wrong it is, how title's in the wrong entity. Somebody forgot to update something. Maybe they missed a maintenance fee date or a renewal date. It's always better to bring me in on the sell side early. So let's look and let's clean that up. Well, sometimes individuals take over companies or companies merge, and we come in and we'll do an IP audit, an intellectual property audit, which basically says, show us whatever you think you have. We'll do some searching online, and we'll figure out what copyrights you own, what trademarks you own, what patents you own, what license agreements you have with other companies, and what else do you have that maybe should have been protected. Maybe it's a trade secret. Maybe it's not. Maybe you just failed to protect it. Maybe you let it fall in the public domain. Maybe you still can protect it, like a trademark that has strength, because the trademark rights come from usage over time. But we'll come in and figure out what you could have done, maybe should have done, and let you know what the situation is to figure out if you want to clean up some of that, either to sell the company or just to run the company better and make sure you know what you own. Those assets are valuable.
Absolutely. And I want to refer people to your site to see the post about the restaurant that came to you for help because they didn't file something correctly and they needed somebody to help. So thank you so much. I've learned a lot. I think this will help a lot of my friends in the digital marketing industry. And thank you so much for your time.
My pleasure. You're a great interviewer, Jan. Thanks so much for having me on the show.
You make it really easy.
Thank you.